All rise, the court is now in session.
Thank you. Please be seated. Good morning. This is the time scheduled for hearings on cases CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Mr. Daybell is here present in court, represented by counsel John Pryor. Also here for hearings, case CR 22-21-1624, State versus Lori Vallow Daybell. Mrs. Vallow Daybell is here represented by her attorneys, John Thomas and Jim Archibald. State's here this morning representing the prosecution, Lindsay Blake, Tanya Rawlings, and Rob Wood. Present. A few preliminary matters I'll bring up as we get started. There is a order governing courtroom conduct that's in effect today. I would note for those in attendance in particular, one of the provisions of the courtroom conduct order is that all cell phones must be silenced or turned off at all times in the courtroom. There's no permitted recording of any type, audio or video by any electronic device. If anyone attempts to do that or a phone goes off, those devices will be confiscated by the bailiff. I'll also note that listening in is another district judge out of Ada County. Judge Stephen Hippler is the administrative judge from Ada County who has worked with us in coordinating the trial for this case at that venue where the trial will take place. Judge Hippler wished to attend the pretrial conference this morning in order to listen in and be aware of any developments that come up during the pretrial conference, as he's integral in the planning of the trial in this case. So that's why the monitor's here, and I'll note his presence at this proceeding. What we've got scheduled for today, first matter we'll bring up is the pretrial conference in this case. After that, there's a state's motion in limine regarding mental health evidence as it relates to the Lori Vallow Daybell case. After that motion, we've got three more motions that Mr. Daybell's counsel has filed: a motion to dismiss the indictment, a second renewed motion to sever, and a second motion to compel. So that's the order the court intends to call things in today. Counsel, where we're going to start with the pretrial conference, let me just indicate a few things. We do have a current scheduling order that's the amended notice of trial setting that was filed in the cases on December 27th. There was also an order entered on February 13th modifying one provision of the scheduling order as it related to the deadlines for disclosure of expert witness reports and expert witness information. So beyond that, we are slated to commence the trial as per the scheduling order. So at this time, let me just inquire, as of the state, is the state going to be ready to proceed to trial pursuant to our scheduling order?
Yes, Your Honor.
Okay. I will note, we discussed yesterday during a hearing that was closed regarding 404B evidence, the witnesses that would be listed in the questionnaire that's going to be given to prospective jurors. The court's finalizing that questionnaire this week, and I believe I now have received all of these states' proposed witnesses to include in the questionnaire. Are those complete, Ms. Blake?
Your Honor, the state does have an updated list that we intend to provide the court and counsel today. I would indicate it was the state's understanding from the pretrial order that we had until 2 weeks before trial to turn in our final witness list. There is a slight chance that there could be a few modifications to that list, but we do have an updated one to submit to the court today.
Okay. And on that issue, Ms. Blake, it is true that the scheduling order does give a later time frame than what we anticipated because of the questionnaire. So if that occurs, you'll still be in compliance with the scheduling order. We're just trying to obviously make the questionnaire as complete as possible to get the best information. So we'd appreciate any efforts of you getting all of your witnesses you can at this point disclosed, and the same would apply for the defense.
Thank you, Your Honor.
Okay. All right, let me move to you then, Mr. Pryor. I believe we also received the disclosed witness list from you. Is that correct?
That is, Judge, and again, that's going to probably need to be updated as well.
Okay, and to the extent you can get those as soon as you can, hopefully by the end of this week, the court would appreciate it, but I do recognize you're still within your time frame under the order. Going back to trial, I know you've got pending motions still to be decided that could impact things, Mr. Pryor, but otherwise, what's the defense position at this point on our currently scheduled trial to start on April 3rd?
We're not going to be prepared for trial, Judge, on that day.
Okay. Well, I'll note that on the record. We'll be hearing more in terms of a substantive argument on that as motions come and are argued. Mr. Who's going to speak for Mrs. Vallow, Daybell? Mr. Archibald, what's the position of your defense team for our trial date?
We're ready to proceed, Your Honor.
Okay. All right. The court would note these cases are joined. There's been several motions to sever. There's also a pending additional motion to sever. However, Mrs. Vallow Daybell's case being scheduled when it is, a big part of what's driving that date, of course, is the speedy trial right that has been asserted in that case. And so that's where we stand, and the court does intend to try these cases together absent a ruling otherwise with pending motions. So I think that's probably about as far as I can tell you in terms of trial. Obviously, we've done a lot of preparation. Counsel's met with me and the administrative judge as well from Ada County for trial preparations. I can't advise you that they're ready there. We've got the courtroom set up and ready to go for our trial dates. That's what we intend to do. So let me just ask then, are there any other issues or matters we need to bring up on the pretrial conference this morning, Ms. Blake?
I don't think at this time, Your Honor. I think defense had indicated there were a few things that we were going to possibly talk about in chambers today, but outside of that, the state has nothing.
Okay. All right. From Mr. Pryor, on behalf of your client, anything else on the pretrial conference today?
Judge, I think you spoke of the three pending motions as they relate to the issues that I've addressed in those briefs and motions. So standing on that, Judge, other than that, there isn't.
Okay. Thank you, Mr. Pryor. Mr. Archibald, anything further to bring up on the pretrial conference?
Your Honor, we disclosed yesterday to the state of Idaho our expert mental health evidence reports. We did not file those with the court. We also prepared a witness list for the jury questionnaire, and we supplied that to the prosecutors and also to your law clerk. And so I wanted to make sure that those were received. Our witness and exhibit list will be fine-tuned as well, similar to the state, and it will be filed with the court 14 days before trial.
All right. Thank you, Mr. Archibald. We did receive the information you sent yesterday in terms of the disclosed expert information. I think, was that only sent to prosecution then?
Yes.
And Your Honor, we did receive both, all the documents that he's referencing.
Okay. All right, counsel, I appreciate your efforts in getting prepared for trial. That will conclude then the pretrial conference for this morning on the case. The next matter we'll bring up then is a motion that was filed by the state. That's the state's motion in limine on mental health evidence. It was filed on January 26th. There was an objection filed on February 2nd, and this relates only to...
Your Honor, the state actually did file a motion in both cases. In Mr. Daybell's case number, the 1624, or 1623, excuse me, it was a shorter motion, more of an anticipatory and just out of an abundance of caution.
Okay, I appreciate the clarification there, Ms. Blake. I do see that now. So in the 1623 case, the state filed its motion in limine on mental health evidence on January 26th. Then in the 1624 case, also on January 6th, there was filed a state's motion in limine on mental health evidence and a memorandum in support. The court did receive those motions. In addition, there was an objection filed in the 1624 case, and there was not a response filed, as I understand, in the 1623 case on behalf of Mr. Daybell. So I believe that matter scheduled for argument this morning. Is the state ready to proceed on argument on that motion?
Yes, Your Honor.
All right. the state would like to present arguments in support of the motion at this time, you may.
And does the court have a preference on which case number we argue in first?
I would suggest calling up the 1623 Daybell case first.
With regard to Mr. Daybell, Your Honor, the state has filed a motion in limine to exclude any use of mental health evidence as a defense to any of the elements or otherwise in a trial in that matter. The reason being, there has been no filing under 18207 to indicate that Mr. Daybell would intend to challenge any mental health condition as a defense in this case. Given that, out of an abundance of caution, we're just asking that the court, based on that, exclude any use of an expert at trial regarding mental health and/or any argument by defense regarding mental health as a mitigating factor during the guilt phase of the trial. The state recognizes during the penalty phase that is a different, there is a different standard applied there, but for the duration of the guilt phase, it's the state's position they should not be able to reference mental health or use it as a defense.
All right, thank you, Ms. Blake. Response on that motion, Mr. Pryor.
Judge, as the statute requires, I'm required to file a notice to the prosecuting attorney that I intend to do that. I don't intend to do that during the guilt phase of the trial. There'll be no reference or use of mental health, and I assume then that the state won't be offering any evidence in that regard either. So given that, Judge, there won't be an objection during the trial of the guilt phase.
All right, thank you, Mr. Pryor. So based on the filing of the motion and pursuant to the requirements of 18207, the court finds the motion is appropriate under the rule and the statute. So without objection, the court will grant the motion that defendant's mental health at the time of the commission of crimes would be excluded as an issue at trial during the guilt phase. So, Ms. Blake, if the state would prepare an order granting the motion as to that case, the court will get that signed and filed in the case.
We will do so, Your Honor.
All right, this time then, if you'd like to argue the second motion as it relates to the 1624 case, you may.
Thank you, Your Honor. As the court indicated, the state already filed a motion and a brief in support of that motion. It's a similar argument in this case, but we went a little more in depth because we're in a little bit of a different position with regard to Ms. Vallow Daybell. Ms. Vallow Daybell, at times, her defense team has brought up mental health in the capacity of competency, and there have been some challenges with regard to competency, some expert reports prepared in relation to that. However, the defense specifically filed a notice of intent not to use a mental health defense under 18207. With that filing, the state's position is that they would be precluded from now attempting to introduce any expert witness or any mental health defense or argue mental health as a defense to any element or other aspect of the case. Under 18207, the state would have been allowed to have an expert meet and evaluate Ms. Vallow Daybell. And the concern for the state with regard to Ms. Vallow Daybell is while the defense has responded and said we don't intend to use a mental health expert during trial, during the guilt phase, they do reference, of course, that 18207 talks about mental illness evidence can be presented if it negates an element of a crime. The concern the state has is we do not want to run into a situation where during the trial there's an argument that the state has somehow opened the door to allow in this mental health defense. The concern with that is the state should not be bootstrapped or prohibited from talking about things that someone could try to spin and indicate her mental health. The state absolutely intends to talk about the issues regarding the defendant's beliefs. And with that, we have a concern that the defense may then try to argue the door's been opened to argue mental health as a defense to an element of this crime, or to add any additional burden on the state with regard to our burden of proof at a trial when mental health is raised as a defense. In addition to that, as we talked about in State v. Oxford, which is 167 Idaho 515, that case dealt with a defense expert or a proposed defense expert that was going to talk about the defendant's mental condition. However, that expert was going to talk about the mental condition close in time to when the report was made, not in relation to when the crime was charged. The state has seen several reports regarding Ms. Vallow Daybell's mental health. As the defense indicated, they recently provided some reports to us just yesterday regarding what they purport that they would intend to use in the penalty phase of trial. Now, the state recognizes the penalty phase is separate from the guilt phase and the standards are separate there. But what we have never seen from defense in any report or from any expert is any evaluation of Ms. Vallow Daybell's state of mind at the time of the alleged commissions of these crimes. And I think without that, the defense would be barred from trying to merely insert an attorney's position or otherwise regarding mental health as argument at a jury trial. And with their being prohibited from bringing in an expert in the guilt phase, we don't want to have that door opened for them to simply present argument or request any jury instruction in relation to mental health being a defense or a mitigating factor in the guilt phase. We recognize penalty phase is separate. The defense made a note in their brief, in their response, that would mean the state is barred from presenting our mental health expert in the case in chief or as rebuttal during the guilt phase. The state's position would be that is not necessarily accurate, and we would ask the court not to make that finding today unless the court makes the finding that the defense will not be allowed to argue or use mental health as a defense during the guilt phase. If at any point that door is found to be opened or they are allowed to present argument or they do present argument, the state should absolutely not be precluded from having our mental health expert come in and talk about that. Under 18207, the requirement is that it be disclosed 90 days in advance of trial if you are intending to use mental health as a defense. There's no requirement on the state to provide that same information. So essentially it appears that the defense is trying to essentially bootstrap their own motion in limine to our motion in limine to ask we not be allowed to use a mental health expert in the guilt phase. The state would concede we would not intend to do that so long as the parameters are set and any mental health arguments on the side of the defense are prohibited during the guilt phase for failure to comply with 18207 and for failure to provide any discovery in relation to that.
All right, thank you, Ms. Blake. Who's responding? Mr. Archibald? All right, Mr. Archibald, if you'd like to offer argument in response to the state's motion.
Your Honor, I filed an objection to the state's motion regarding mental health evidence. My argument today is similar to what I stated in that objection. And so we acknowledge that Idaho Code 18207 provides that mental illness is not a defense to a crime. However, mental illness evidence can be presented if it negates an element of a crime. And so what that means is that if Lori Vallow Daybell ever said, I did it, but I was crazy, that's where 18207 applies. And because she has never said, I did it, then 18207 is not applicable to negate an element of a crime. And so in our mental health assessments, all the mental health experts that have evaluated her from the state hospital to our experts say, yes, she does have a mental illness. There's no question. And however, since she's never said in here or anywhere, since she's never said, I did it, but I was crazy, then 18207 doesn't apply. So that's why the mental health evidence that we intend to present is if she's convicted. She believes that she will not be convicted, and so the mental health evidence should never be presented. And so, however, we have to, these capital cases are unique in that we have to prepare for sentencing at the same time as trial. So that's why we have submitted our experts in the event she is convicted, then we intend to present our mental health evidence at that time. And the mental health evidence would not negate an element of a crime if the jury found her guilty. However, it would be mitigation for the jury to consider the punishment. And so that's where we're at. We haven't hit the ball. our mental health experts still have questions about her competency. We acknowledge and respect the court's determination that she is competent to proceed to trial, even though there are differing opinions about that matter. And so I see this motion as the state of Idaho really wanting to call their expert in their case in chief. And I think that's wholly inappropriate. They put Dr. Wellner on their witness list, and and I'm guessing they would love to call him in their case in chief. But since we're not going to make that an issue, then the state should be precluded as well. So I'll make a motion, since the state mentioned it, I'll make a motion in limine right now that they be precluded from calling Dr. Wellner in their case in chief. If they want to call him, if she's convicted, if they want to call him during the penalty phase, that's appropriate, but not during guilt phase. And so that's our position with Idaho Code 18207. And we haven't hit the ball, and we filed our notice that we're not going to call mental health experts, based in part because of the court's ruling that she is competent. And so, and those matters were sealed, so I probably shouldn't talk too much more about that. But that's our position, Your Honor, and we're not hiding the ball. I am concerned, however, with them putting Wellner on their witness list, that they might be wanting to call him in the case in chief, and that should be excluded.
All right, thank you, Mr. Archibald. So I want to hear a response from the state. I'd note also there's been an oral motion made on the record at this point now, and a motion in limine where the defense is requesting that Dr. Wellner be precluded from testifying during the state's case in chief. Given the issue is before the court, I obviously understand there could be a timeliness argument on that, but given where we're at with the trial coming up, and it is a motion in limine, I think it is appropriate to hear argument on that today on this oral motion that was made in addition to the response made. So Ms. Blake, if you're prepared to address that, I'll hear your argument at this time.
Thank you, Your Honor. As the state previously indicated, when we look at 18207, it's mental condition being used as a defense is what that section is referring to, and that if so the state's position would be that we would have not been subjected to the same requirements under 18207. We wouldn't have had access to the defendant to provide any report or to allow the defense experts access to her. However, the state's concern is that if the court does exclude Dr. Wellner, the state is the one that has the burden of proof and would need to evaluate evidence and present it appropriately to the jury as the trial unfolds. So if at any point mental health does become an issue, whether it's in part due to the state's burden of proof to prove every element, or whether it's because it's raised by defense, the state may determine it's necessary to call Dr. Wellner to put things into context for the jury. The state's concern is, given representations made by defense today regarding Ms. Vallow Daybell, that multiple experts believe she has a mental health issue, we are concerned that at some point during the trial that will be argued, that will be raised, and the state should absolutely have the ability to ensure that we're able to prove our case beyond a reasonable doubt and to present any evidence that is necessary for the jury to hear.
Well, procedurally then, do you intend to call Wellner in your case in chief? It sounds to me like that would be more in the form of rebuttal testimony potentially, but is he somebody you intend to have testify in your case in chief at this point?
I don't think at this point, Your Honor, but we would hesitate or be concerned if the court absolutely precluded the ability for the state to call him in our case in chief. While we are making it sound like, and I think at this juncture our thought would be more rebuttal. Obviously, as the trial develops, depending on what questions are asked by defensive witnesses, depending on what ideas or theories are being thrown out there to the jury, the state may make a determination at some point that it absolutely is necessary for Dr. Wellner to come in and provide testimony in the case in chief to put things into perspective for the jury, and to avoid a situation of attorneys trying to comment on or make specific findings or insinuations regarding mental health and its applicability to the commission of the crimes. Again, not looking at the current state of mind of the defendant, but going back to the time when the crimes were committed. If that becomes an issue at any point through questioning of witnesses, through cross-examination, the state may determine it's necessary to call Dr. Wellner. At this juncture, the state is not intending to call him in our case in chief, but we do have him on our witness list and would want to reserve that ability.
Okay. Where you made the motion, Mr. Archibald, and I allowed for a response, I'll give you one more bite of the apple here and have any rebuttal argument you wish on the issue of your motion in limine to preclude Dr. Wellner.
We do not intend to open the door. We do not intend to make mental health an issue during the guilt phase. So they don't plan to call Wellner in their case in chief, and we don't bring up the issue, then he would not be a rebuttal witness as well during the guilt phase. And so it sounds like they're conceding that they're not going to call him during their case in chief. And so I appreciate knowing that we certainly don't intend to open the door, because our witnesses will be very few during the guilt phase.
All right. This motion, the court can grant in part the motion in that the defense has agreed in their response here in pursuant to 18207 that during the guilt phase portion of trial that no expert witnesses would be called by the defense to support a claim under Idaho Code 18207. So as to that part of the motion, the court does grant the state's motion in limine. As it relates back to Dr. Wellner and the motion in limine that was taken before the court today and the other additional issues brought up by the state in their memorandum and argument today, the court's going to take those issues under advisement and will issue a written ruling prior to trial to give you some guidance on whether or not Dr. Wellner would be allowed to present testimony in the case in chief during the guilt phase of the trial or not. And the other issues you've raised, Ms. Blake, will do our best to get an order to give the parties direction so they know how to proceed during the evidence portion of the trial. So granted in part and under advisement for that other part for a written ruling.
And would the court like any partial order prepared on that, or is the court going to prepare the full order?
I think on that we'll just prepare an order, so we'll incorporate the ruling today from the bench into that order, into an order that will cover the rest of the issues as well.
Thank you, Your Honor.
All right, thank you. Anything else on the motion today on that one, Ms. Blake?
Not at this time, Your Honor. Thank you.
Okay. At this point, then we've got additional motions that are brought exclusively on Mr. Daybell's case, 3 motions. Mr. Archibald and Mr. Thomas, if you'd like to remain present with your client for those motions, you may. If you'd like to be excused at this time since they are not filed in your case, you can do that as your preference to remain here and hear the motions.
Yes, since it does affect our trial as well, we'll remain if that's okay.
Okay, we'll go ahead and proceed with the motions then, and you can be here to observe along with your client. So, Mr. Pryor, then, in this case, we've got the first motion of yours. We'll take up your motion to dismiss the indictment or to preclude the imposition of the death penalty due to continued discovery violations by the state. That was a motion filed on February 10th. The state filed a response to the motion on February 16th, and then you followed up with a reply brief filed on February 21st. The courts reviewed those pleadings, and they're scheduled for argument this morning. Are you ready to proceed with your argument on that, Mr. Pryor?
Yes, Judge, and permission to remain seated?
Yes, that will work well with the microphone. So, Mr. Pryor, if you'd like to present argument now on that motion, you can do so.
Judge, in this particular case, I understand that the court set a deadline for disclosure of discovery. The difficulty is there's a difference between a requirement that the state provide discovery within a deadline set by the state and a time that the state provide me with information that's in their possession that may be either exculpatory, possibly exculpatory, or that could provide the defense with information that may mitigate in this particular case. The concern that I have, Judge, is this, is that at today's date, I believe, if my calculations are not incorrect, the trial in this case is going to start in 21 business days. That's 21 business days. Now, to date, unless I'm mistaken and I missed something, there is DNA evidence that's still outstanding that I don't have in my possession. Now, that DNA evidence that I don't have, Judge, was acknowledged by Ms. Smith when the court asked, is this exculpatory evidence? And Ms. Smith, in a hearing in public, acknowledged that it's exculpatory evidence. She said that. Now, Mr. Wood and Ms. Blake would...
Object to that characterization.
You can raise that up in your rebuttal argument.
The difficulty, Judge, is it's not their determination to determine whether or not the evidence is exculpatory. There is DNA evidence. That DNA evidence has not been provided to me. I submitted an affidavit or a declaration by my expert, Dr. Hampinkian, who at this point, until I receive that evidence, is of no use to me in this case, at least from my perspective. In that declaration, he had indicated that he's going to need about 8 weeks before he is able to provide a report to address that DNA evidence. This isn't a defense problem, and this should not be put on the defense. It's not my problem about the DNA evidence and what's going on. This is all on the state. They have an obligation to proceed and process DNA evidence. This case started in 2019. The entire time, the source of that DNA evidence has been in the exclusive possession of the state since 2019. In late December, I'm notified that there is some additional DNA evidence. We immediately entered into a stipulation to try to get that processed as quickly as we can so that I would have this. It became abundantly clear, Judge, that I wasn't going to get that evidence, and to date, I still don't have that evidence. I want that evidence. I want to process it. I want it tested. I want it examined by my expert. This isn't a grand theft case. This isn't a DUI case. This is a capital murder case in which the state of Idaho and those prosecutors are trying to impose the death penalty on my client. The results of this can't get any more serious, Judge. This is the most serious kind of case that you can be involved in. And I take that job and obligation very seriously. And this court on the record at the last hearing said, I'm not going to allow the state not to turn this evidence over at the last hour and not give you an opportunity. Judge, that is well past. It's time. They've had every obligation. And one of my concerns in this case, Judge, is this. The source of the DNA evidence has been in their possession, like I referenced earlier, since 2019. In December, they suddenly discover additional DNA evidence. Surprisingly, more DNA evidence. That's not on me, Judge. That's their problem. That's their difficulty with their experts not either doing their job or doing a very, very sloppy investigation of this case. And in either case, Judge, and if they're just trying to put it on me at the last minute and trying to sandbag me with this, and I hope that's not the case, in either event, Judge, it's blatantly unfair that you're going to hurry me, you're going to rush me into having to do this job and evaluate this stuff in 21 business days because they can't get their act together. They can't do their job and give me sufficient amount of time to do what I need to do in this case to evaluate the evidence. And they don't get to rush me when, according to their most recent, and Judge, I'll point out that they sent me a certified mail, I think last Friday. We were involved in this case, and I didn't get it until Monday, the holiday, and FedEx met me at my office on the holiday so I could sign for it on Monday. And that's chain of custody evidence. That's the most recent chain of custody evidence. And thankfully, Judge, I ended up spending the last 2 days going through all of that chain of custody evidence and examining it. But I don't have it to my expert yet. And I can't get it to the expert because I'm here. And now I have to overnight that to my expert, have them evaluate that in 21 days, and hopefully get a report to this court relating that chain of custody evidence. That was on the 21st of February. Again, they're rushing me. The significance is this. That chain of custody evidence, at least portions of it, have been in their custody and their care and their control, and all 5 or 6 or how many lawyers you have now, since 2019. And they think it's okay, Judge, for them to get me this evidence 2.5, 3 years later after all of this evidence is processed. They can make all...
Could you clarify, you're talking about chain of custody evidence. I mean, typically a chain of custody is just kind of a list of where the evidence went. What are you referring to specifically when you talk
and Judge,
chain of custody
if the court wants me to identify specifically what it is, I can do that. If you want me to talk about that, I've been trying to avoid the court's interim order, which talks about not talking about specific discovery. But if this court would want me to do that, I'd be glad to discuss that.
Well, at this stage of the proceedings and where we're at with this DNA issue, it's been brought up there. I don't think it violates the protective order that was issued in this case. I want to know what it is you're referring to specifically as to chain of custody evidence. The other thing I wanted to clarify, and you referred to my comments at the last hearing, which of course I remember, that this issue on DNA, as I understood it at the time, the question was, is there DNA? Is there sufficient DNA developed that could be tested? And I'd like you to address whether or not the status of the answer on that issue and then what's been provided, so I can have a clear understanding of just where things stand on this DNA issue.
Okay, Judge, my understanding, at least from my reading, is that and what Dr. Hampinkin disclosed to me, is that there is sufficient DNA evidence. There was communication with the state in which there is a testing procedure that was set forth in which the state had indicated that if they send it off to this special lab, that they would have the results back in 3 weeks. 3 weeks, I believe, was a day or two ago, and we still don't have the evidence to my knowledge. If they have provided it, would they please tell me how it's provided, because I don't have it. And I don't have it in my possession, and unless somehow it's in that disclosure they just gave me on the 21st, which was Monday. I didn't see it in there. There was reference to other DNA evidence. That DNA evidence included hair samples from each of the respective defendants in this case, and its processing and its sealing and some of those things. Now, it did go forward beyond 2019 to the sending of those samples to the lab that initially did the DNA sample. So there is some of it that's recent, but there's also some of it that goes back to 2019, and that's problematic, Judge. And again, putting this discovery on me on the 21st of February, when I have an expert, and they know I have an expert, who has to evaluate this stuff and look at chain of custody, it's an impossible task. And the reference that I made, that I'm not ready for trial, this is going to apply to each and every one of these aspects of the evidence that this state has decided at the last minute to provide me, for lack of a better word, at the last minute at their convenience. Now, the next evidence, Judge, was provided me on the 13th of February as well. That was the 11th supplement. The supplement after that was provided me on the 6th. That was the 10th supplement. The supplement on the 9th supplement was provided February 5th. So now in the month of February, Judge, just in the month of February, there have been 4 supplements. Those supplements include tips that were involved in this case from 2019. Tips that have been in the possession, and the state addressed that, and quite frankly, I responded to that in my reply, and I won't go into a great amount of detail, but the reality, Judge, is that if it's just something identifying tips, why are there 1,188 pages of tips? And I will let the court know that I haven't even begun to look at those 1,188 pages, because I've had to deal with other matters that are much more urgent at this point. And if the state doesn't think that's important, the importance is simply this, Judge, is if there's information as a result of those tips that's helpful, and I don't know whether there is or not, but it doesn't matter. The fact is they didn't provide me these tips, and these tips are from when this case started. Again, 2019, 1,188 pages. Now, they filed their service of this on the 5th, Judge, but the reality is that counsel and I were present on the 2nd of February for a meeting with the court about the trial, and Judge Hippler was actually there as well. He was listening in today, and the state handed us, both of us, an envelope and said, oh, by the way, here's some tips. We didn't realize we didn't get you these. And here they are. Now, if they inadvertently missed something and they didn't provide it in a timely fashion, that's fine. But it doesn't excuse the fact that I don't have to be forced to rush through evidence and review these things at the last minute and try to be prepared for trial because the state can't get their act together. And the fact of the matter is, Judge, is that other than the GPS and the DNA evidence, which was also disclosed late, and the tips, as far as the DNA evidence, that's the only stuff I think is going to be, that I'm almost certain is exculpatory evidence. The rest of it I don't know yet because I haven't had a chance to go through it. And that's because they've been spending the last month of February disclosing all of this stuff that's been in their possession for a significant amount of time. I'd also point out on the 14th of December of 22, that's when the 8th was disclosed. And then on the 7th of December of 22, the 7th supplement was disclosed. So by my count, Judge, in the last 2 months, give or take a few days, they've provided me 6 supplements. That's not what this discovery order was meant to do. Then the state files a 404B. And they say, we want to introduce this evidence, particular evidence. There's a hearing on that. The court wants that fine-tuned a little bit. And lo and behold, they show up and say, oh, by the way, some of this 404B evidence that we want against Mr. Daybell, we're going to use in our case in chief. Now, the stuff that they're talking about in the 404B in their case in chief, Judge, is absolutely related to the 12 terabytes that they've not provided yet. And there are over 12 terabytes of evidence that they've not provided. And we've asked that the court provide us, or at least that they provide that to us.
Is this the evidence you're discussing from electronic devices?
It is, Judge.
Search warrant? Okay.
It is, Judge. Now, the concern with the electronic device is this, Judge. Given the fact the state did notice in their inventory some of the electronic devices, they itemized some of the electronic devices. And then what they did, Judge, is they've obviously downloaded all of that information. 12 terabytes of information. Now, 12 terabytes would fit in the back of a cargo van. That's how much evidence is 12 terabytes of information. But what they did is they downloaded it, and then they took piecemeal pieces, small pieces of that evidence, and they injected it into the discovery as they provided it. They didn't identify it specifically. They just said, oh, here is some of this evidence, little bits and pieces. But what they didn't do, Judge, is they didn't give me all of the evidence. Instead, they're relying on the statement that they make. The defense can go down any time that they want and copy this evidence or review this evidence at your leisure. Judge, I don't have the leisure to sit in their office and go through a van or a truckload full of evidence. And they've been sitting on this 12 terabytes of evidence from the beginning of this case when they went to Mr. Daybell's house and obtained a number of electronic devices, 32 electronic devices. What they didn't disclose in the discovery and what they didn't disclose on their list and inventory are the 26 journals that they did not provide. I'm not aware, and if it is in there, I see Mr. Wood shaking his head. I missed it then, but there's 26 journals that have not been provided. They took pieces of those, Judge. Now, I don't know how much free time any lawyer has given their involvement in a capital crimes case, Judge. But my understanding is that if I provide and show up with a hard drive that takes 12 terabytes, it's going to take them a week for me to sit there while they download it onto a computer. And it's going to take me 3 months to go through all of the discovery on the 32 devices and the 26 journals. And to suggest that I'm to do that and sit down because the state has elected to confiscate evidence from Mr. Daybell's house, and then require me to sit down they are not allowed to make this onerous, difficult, or for all practical matters, an impossible task. Now, for the record, I provided the state's support staff a 16 terabyte hard drive. This isn't something, Judge, that I can go to Walmart or to Office Depot or Staples or anything like that. Not possible. You can't buy it in a store, and I went to 3 or 4 stores trying to find a large enough external hard drive to accommodate that information. And last week or a week and a half ago, last week I believe, the state notified me it's 12 terabytes. So I had to order it special and have it delivered. And once it arrived, I then was able to deliver it to them today for them to start the process of downloading 12 terabytes of evidence. They are not allowed under the discovery rules, Judge, to sit on this evidence and say, well, if Mr. Pryor decides not to pick it up, he doesn't get to pick it up. That's not the way it works. And the fact now that under their 404B, change of heart, for lack of a better word, they've decided that in their substantive case, that 404B evidence, they think they're going to get it in the case in chief. That makes it substantive evidence. And if it's substantive evidence, they are required to provide that to me. And Judge, even if they get it to me next week, I'm not going to get through it all. There's no way. I can't get through it all. Even with the additional support staff I have, there is no way that I'm going to get through that evidence. It's an impossible task. So this is becoming a recurring theme, Judge, and I haven't touched on the 2 motions to compel when I had to compel them to provide evidence. And we have one coming up, and that's on the DNA evidence that I still don't have. And if the state has provided it, please let me know, and let me know where in the evidence that it is, because I don't see it. But Judge, throughout this case, throughout these disclosures, they've been providing evidence or disclosing certain evidence. And what the pattern is this. They provided what's called a Faro scan. And a Faro scan is a technical document that forensics experts use, and without going into more detail. So what they did is they provided me with a Faro scan as one of these disclosures. And instead of giving me all the technical information, what they did is they gave me a face sheet that said Faro scan on it and nothing else. So I file a motion to compel, I do a specific request, and eventually, in the last month and a half, they've been able to get that to me. Now the GPS, same thing. Gave me a face sheet, said, oh, here's a picture of the GPS evidence. And I said, wait a minute, you got to give me the nuts and bolts, you got to give me the technical information. And during one of these disclosures in the last 5 or 6 weeks, they then provided me with 500,000 waypoints that are still being processed by my GPS expert to evaluate one of the phones that we're looking at. The suggestion that they've done otherwise is ludicrous. And if they make that reference, Judge, they're misleading you. Because there is no way that they have provided this information in a timely manner. But this habit of providing partial disclosure and partial evidence, what that tells me, Judge, is this. They have the evidence in their possession. But instead what they're doing is they're providing little bits and pieces and saying, catch me if you can. Provide it to me if you can. And how do I know that? 500,000 GPS waypoints that were never provided originally. 1,188 tips that were not provided and provided now in the less than the last month. Chain of custody that they've had in their possession since at least August of last year, because it was signed off by their chain of custody expert on August 16th of last year. And if the court wants to, we can take a break. I can print off a copy and show you their expert got the GPS or the DNA evidence on the 16th of August, and that's when they received it, and now I'm getting it on the 21st of February. Some 6 months later, chain of custody evidence, DNA evidence that magically appears, and now suddenly they're deciding to provide me the DNA evidence. The chain of custody evidence, their decision not to provide me the 12 terabytes of evidence, the GPS evidence, the tips, the interviews with other witnesses that occurred, some of them occurred over a year ago, that I'm just getting now. Some of them are more recent, but I'm just getting them now. Now, either it's one of two things, Judge, and I hate to say this, but it's one of two things. Either they're trying to sandbag me, or there's a lot of incompetence, and nobody's watching and directing the ship. And either one of those is not my fault. And for you to punish me and require me to go through all of this evidence at the last minute because they either can't get their act together or they're trying to pull one over is not my fault. And when I make a representation that I'm not going to be prepared for trial, it's because of the reference of these 6 disclosures, the results of 2 motions to compel where they had to give me additional information, and this has all been done in the last 6 to 8 weeks. And some of this information they've had for several years. Some of this information goes back to their experts from August of last year. And they're going to rush me on a capital murder case to get this done. I've had a discussion with Mr. Daybell. I told him what I was going to tell the court today. I said, Mr. Daybell, I've done everything I can to be prepared for this, but this prosecuting attorney's office cannot continue to do this and disclose this very technical information to me at the last minute. And the suggestion that I should have to show up at their office and say, oh, I'm going to make an appointment. Would you block out 10 days for me, Mr. and Mrs. Prosecutor? Because that's how long I'm going to need to sit in your office to download the information. And I'm pretty sure you're not going to let me do that. That's the significant amount of information that I'm going to have to sit and download. I can't speak for Mr. Thomas and Mr. Archibald, thank you. I don't know how I would ever forget his name. It's going to be ingrained in my head the rest of my life. I can't speak for them as to why they're going forward. I know they don't have the 16 or the 12 terabytes. I know they don't have the DNA evidence. I know they, for all practical purposes, I don't even think they have the GPS evidence yet. I don't know. But they're going forward with this thing, and I don't know whether that's Ms. Vallow Daybell, excuse me, ma'am, insisting on this. But I'm representing to the court that the vast, significant amount of discovery has made it impossible for me to be ready for the trial. Impossible. I can't be ready. I haven't even started working on getting witnesses subpoenaed and ready because all of my time has been spent dealing with these motions and trying to get through discovery as quickly as I can. This has gotten to the point, Judge, where their failure to provide the discovery and the fact of the matter is they're going to set up there and say, prove, Mr. Pryor, that it's exculpatory. Well, Judge, the DNA evidence, the court specifically asked them, is it exculpatory? And they can make whatever reference they want today, but the insinuation, Judge, is it was exculpatory evidence, and evidence that I don't have at this point. The rest of it, I can't tell you whether it's exculpatory or not. I can't, because I haven't gotten through it. And the 12 terabytes, I know they're now going to use some of this for their case in chief and substantive evidence. I don't know. I don't have it yet. 21 days before the trial, and I don't have a significant amount of evidence because they've been sitting on it for whatever reason. And they can come up with excuses and say, Mr. Pryor could have showed up at any time. It's not our fault that these other organizations are slow in getting us the information. That's not my problem. That's not my difficulty. That's their problem. If they can't get the stuff to me, that's their problem. This delay is not on me in any way. This delay cannot be imputed on me in any way. This is a complete breakdown of this prosecutor's office in providing me the information, or it's something even more devious than that, Judge. And that is a concern. And based on that, Judge, I'm asking you to dismiss this indictment. In the alternative, Judge, if you don't dismiss this indictment, I'm asking the court to consider and reconsider the severance motion. Because as I've represented as an officer of the court and all of the representations of this evidence, I cannot be ready. I look forward to hearing their explanation then, Judge, as to why the DNA evidence is not there yet. And if it is there, would they please point out where in this vast amount of evidence they've decided to insert it so I can sort of locate it and start the 8-week process of Dr. Hempinkian trying to get a report done, which I guess that would mean the report's going to be done during the trial and I won't have it as part of my case in chief when Dr. Hempinkian starts to evaluate this DNA evidence. Thank you, Judge.
All right, thank you for the argument, Mr. Pryor. Who's responding on behalf of the state?
Your Honor, I was going to respond to the motion to dismiss the indictment or remove the death penalty. I think we've kind of conflated some of the issues with the motion to compel and the severance here in counsel's argument, but I'm prepared to address the motion to dismiss the indictment.
Well, on that point, we do have a renewed motion to sever. There's also a motion to compel. We went into a lot of argument on those as well. I'll still reserve additional argument on that in response to cover them in turn. So at this point, Ms. Rawlings, if you'd just like to address on the motion to dismiss the indictment, I'll go back to Mr. Pryor, ask him if he has any additional argument on the motion to sever, and then do the same on the motion to compel, so you can narrow your response down, if you wish, to just the indictment motion.
Thank you, Your Honor. And I am going to ask the court's indulgence in referring to...
If you could bring the mic a little closer.
Okay, sorry. I'm going to ask the court's indulgence in referring to co-counsel because much of the information might have been handled by one specific prosecutor. With regard to, I think I just want to clarify first off this chain of custody evidence and the DNA evidence. With respect to the DNA evidence that was recently additionally collected by the state lab and which Mr. Pryor was notified of immediately upon the state's learning of it in December 2022, that evidence was not collected until the bodies were discovered on Mr. Daybell's property in June 2020. So chain of custody evidence referencing anything in 2019 would have been unrelated to that DNA evidence. It would have been devices or things like that, things related to the children's search, anything related to that in 2019. With regard to the DNA evidence, again, during the process of consumptive testing, and I guess I do want to go back a little bit, while it is true that this evidence was obtained by the state in June 2020, and evidence that was not consumptive or was not subject to consumptive testing was tested immediately, and the results were provided to the defense in a timely manner as soon as the state had it. With regard to the evidence for consumptive testing, there were disagreements previously in the prior case. I believe that Mr. Pryor had objected to consumptive testing in April 2021 in the prior cases, and there was a delay in terms of proceeding in that manner with the stay in the co-defendant's case. However, the state did eventually file the motion, and a stipulation finally was worked out with defense counsel, but there were discussions that were ongoing through 2021 and then once Ms. Vallow Daybell was competent in April 2022. With regard to the viability of this DNA, we had indicated to Mr. Pryor when we learned of it from the state lab that these additional hairs, the state lab wasn't sure that it would have evidentiary value or that they would be able to get any DNA profiles from it. And I think that was the representation that Ms. Blake made to the court previously, is that we did not know whether they had exculpatory value or not at that point. In fact, the state lab has tested them, and those results have been provided to defense counsel, and they were not able to obtain a DNA profile. Now, we recognize that having collected these additional hairs at a later date, is problematic. And so the state, out of concern with that, did make some pretty significant efforts to find a private lab that could test smaller hairs that don't have the root associated with it. And there are...
Let me back you up a step there. So where we were at the last hearing, the question I had that was raised by the defense is whether or not there's a testable amount of DNA. And you're saying the answer the state lab gave you was no, there's not.
Yes, with the equipment and their testing procedures, the state lab was not able to obtain a usable amount for a DNA profile. Okay,
and you're saying that perhaps another lab now has a better testing capability that could develop a DNA sample?
Yes, and so in discussions with the state lab analyst and the equipment and the ability of that facility to test, we did discuss whether there was the option to obtain mitochondrial or Y chromosome DNA from private labs that have different equipment or different processes. And the state made some pretty significant efforts to find a private lab to do that. We contacted defense counsel regarding that, and that is the stipulation that Mr. Pryor is referencing that took place rather quickly in January once we were able to locate a private lab in California that could test those smaller hairs for that type of DNA evidence, and could also give us a quick turnaround because we did contact a lab. I think it was Bodie Lab, and I don't remember exactly where they are located, but their turnaround was significantly longer, several weeks. And so the state made, I think, a diligent effort in trying to address the late collection of these additional hairs in case they do have any exculpatory or evidentiary value. Again, we don't know whether they do.
What's the current status of?
We expect the report today. We do not have it yet, but we're hopeful that we'll get it today.
All right, well, just as a follow-up, I would like to be advised of the results of that report because it's going to be integral to this decision I'm making on these issues today. So once the state has that, in lieu of waiting for our next hearing date, I'd like to be advised.
Certainly, Your Honor. And just to be clear, we don't know whether they will be able to obtain anything. They just had the ability to test these in a more extensive manner than the state lab.
Okay.
The defendant's request to dismiss the indictment is an extreme remedy that is not justified. The discovery deadline has not passed. The state is aware of its obligation to continue to provide discovery as information becomes available. And we will continue to do so. We will notify the court and counsel as soon as we have this report. We're hopeful that we will have it soon. It's not reasonable to request dismissal of the indictment when information has been shared with the defense prior to the discovery deadline and while the defendant can make use of it. Much is made of the potential for exculpatory evidence, but again, information is considered exculpatory or mitigating only when there is a reasonable probability that its disclosure to the accused would have led to a different result, and that's from State versus Langford that the state referenced in its brief. I think it's noteworthy, Your Honor, that much of the materiality analysis is conducted after a trial has been held and a conviction entered. The defendant continues to couch his complaints of discovery violations as Brady issues without being able to meet the test of Brady. Instead, we are dealing with complaints that are related to motions to compel for discovery for evidence that has been turned over before the deadline of February 27th. Remedies related to motions to compel prior to trial include requiring the party to provide the discovery within a limited time frame, continuances, exclusion of witnesses or evidence, or other sanctions as the court determines appropriate. Dismissal of a case for a pretrial discovery violation is an extreme and unjustifiable remedy. And again, we're not conceding that there's been a discovery violation here, but the argument is that what the defendant is requesting is not appropriate. It's a little bit frustrating, Your Honor, to try and go through, and I fully empathize with defense counsel in terms of going through the vast amounts of discovery. I myself am late to this case. I have not been appointed on it for a lengthy period of time, and I recognize that there is a vast amount of evidence. The state, in an effort to make sure that everything we have turned over previously, has been going through discovery since probably November, going through things and making sure that everything that we have turned over was correct and they're not corrupted. We've had problems, I think, with corrupted files that were discovered after they'd been turned over, and this information just wasn't known to the state. There were a few things in addition, I think, that we thought had been copied over from different law enforcement agencies and then were not. For whatever reason, they just didn't copy over into our cloud discovery file. So we've been going back through everything to make sure that everything that we have supplied to this point is actually there. And that is the reason there have been some recent further disclosures, because we discovered, in an effort to try and be diligent and make sure that everything that we have is turned over and is uncorrupted, we discovered that there were some items that hadn't copied over or that the files had become corrupted. Anything regarding the 404B evidence, anything that we plan to use for that has been turned over long ago. And I just want to be clear that the devices that are referenced by Mr. Pryor that were found in Mr. Daybell's home in January 2020 do not contain any information that the state is intending to use for 404B. Any relevant information that the state intends to use in its case in chief has already been turned over, but we are talking about a number of devices that were used by a number of members of the family and the household, and things that are not relevant to the state's case in chief were just kept on the devices and made available for the defendant to come in and look at as required under 16b4, ICR 16b4. Again, these devices are Chad's or his family members, and we feel that he is in the best position to know whether there is any other items of evidentiary interest to him or anything exculpatory. Again, through the state's review of this information, anything that was exculpatory or of significance to the case in chief has been previously provided. With regard to the journals, they were on the evidence list and were disclosed prior to the indictment in this case. They were disclosed in the previous case, so the defense has known about the journals for a significant period of time as well. With regard to I think it was the cast and Faro data, we did provide some summary information, but we also provided all of the information with the waypoints on that so that his defense expert could look through things and have that information to prepare a report. With regard to the tip information, we just want to clarify that this isn't 1,188 tips. This is 1,188 pages that contain information regarding the tips and a summary sheet. The tips themselves are sometimes small, and so while it sounds like a voluminous amount of information, many of these pages themselves are almost blank. But each tip was contained on a single piece of information or a single piece of paper, if that makes sense. There may be like a few lines at the top and then the rest of the page is blank.
Can you explain the delay in getting those turned over?
Yes. The state learned of their existence at the end of January. We were not aware that they were in the possession of law enforcement. The prosecution team learned of that at the end of January and provided it on February 2nd, as noted.
Of 2023?
I'm sorry?
February of this year?
Yes.
Okay.
Yeah, we learned, the prosecution team learned that they were in, I think, the Rexburg Police Department's possession, and they were in reference to the search again for Tylee and JJ, who were missing at the time. I should be clear, though, and clarify that information that had been determined to be of evidentiary value or by law enforcement that was followed up on and investigated, that information was turned over earlier, but the substance of the reports, including, I think, as mentioned in our brief, psychics and visions and things like that, the rest of that had not been turned over. Again, the state disagrees with this characterization that these are Brady or discovery violations. In response to the defendant's reply suggesting that the state is obligated to provide copies in searchable format with an index that flags any potential Brady material, the state disagrees. The case law that was referenced by Mr. Pryor in his brief is persuasive authority, and it is not controlling. What is controlling is Idaho Criminal 16, which requires the state make such information available to the defense for inspection and copying. As all parties acknowledge, there is a voluminous amount of information, and much of this material has been available for inspection and review for approximately 2 years. The defendant's main argument is that data from devices seized from his home may have mitigating information. However, again, the defendant is the best one, or is the one in the best position to know such information and whether it is also included on electronic devices he or others of his family may have used. And this is similar to the case of U.S. versus Palullo, and I'm probably mangling that, sorry, that was referenced in the state's response to the renewed severance. Furthermore, the Supreme Court has rejected a standard of materiality that focuses on a defendant's ability to prepare for trial, and I think that's been the focus of the argument today. In this case, again, discovery evidence has been disclosed prior to the deadline. Much of this evidence was disclosed previously or made available. This is true for the tips information as well. There may be some information that could aid the defendant in preparation for trial, but this does not transform the evidence from psychics or otherwise into material exculpatory evidence. Although the defendant argues that there may be some information related to alternate perpetrator theories, the state is under no obligation to single out particular pieces of exculpatory or potentially exculpatory evidence pursuant to Rhodes v. Henry. This information has been turned over in a reasonable time frame for the defendant to make use of in trial preparation and before the deadline for discovery has passed. Again, any relevant information from the tips was provided previously, but we acknowledge that the substance of all of the tips was turned over very recently once the prosecution team learned of it. And we were unaware that they had not been, that the full tip file, I guess, for lack of a better word, had been turned over previously. Once we learned of that, we did turn it over promptly, as mentioned. Regarding the DNA evidence, I just want to clarify, I feel the defendant in his reply brief mischaracterizes the state's explanation, and I may have covered this a little bit earlier, Your Honor, but since the indictments against the defendants were filed and the stay entered in the co-defendant Vallow Daybell's case, and once she had been arraigned, the parties engaged in a number of filings. Again, discussions had been ongoing regarding evidence and consumptive testing. And some of those discussions were in the form of objections where Mr. Pryor was not agreeable to consumptive testing by the state lab. Procedurally, the state noted that there was a stipulation to process this DNA evidence that would be consumptive, and that was signed by the court in August of 2022. During that process, the state lab analysts collected these additional hairs that, although they were unlikely to yield DNA evidence according to their analysis, were set aside, and the state was notified of this potential evidence. Defense counsel was immediately notified when prosecutor Wood learned of this. There was not a delay in testing the evidence found on JJ's body. Any evidence that was not consumptive was tested promptly. There was a delay in testing evidence that would be consumed until all parties could be included in that decision. And again, as noted, the state lab has already tested these hairs and has been unable to generate a DNA profile, and this information has been provided to the defense for their expert. As noted, there is an outstanding report regarding these newly collected hairs from the private lab that has been stipulated to by the parties. The state has made an effort to recognize this and stipulated to extended deadlines for expert analysis and reports. And so we feel that we've been diligent in responding to all discovery requests and making all evidence available to the defense as needed. And we would ask the court to find that there is no violation of the due process rights for Mr. Daybell in regards to the discovery violations and deny the motion to dismiss the indictment or set aside the death penalty.
All right, thank you, Ms. Rawlings.
Thank you.
Mr. Pryor, response on that?
Judge, a couple of things. I want to point out, I'll start with the tips. 1,188 pages. It's a mischaracterization to suggest that each page has only one tip. I've discussed this with Mr. Thomas, Mr. Archibald, and quite frankly, there are a number of pages that have 3 or 4 tips. But there are 500 tips. 500 tips on 1,188 pages. So the concern is this, Judge, is that these tips have been in possession of law enforcement behind me, some of them, for a significant amount of time. And I did misquote counsel. You're correct. June 2020 instead of 2019. I apologize. It was June 2020. You're correct. So rather than 3 years, Judge, it's only 2.5 years. So it's only been in their possession for 2.5 years while they've sat on these tips. Judge, this isn't a situation where you hand me 500 tips and say, well, this is information that we got. We don't know if there's any value to it or not, but here it is, and we gave it to you on February 2nd. The notice obviously filed February 5th. 21 days, 3 weeks ago, Judge, they gave me 500 tips. Oh, we inadvertently forgot to give that to you. That's not an excuse. And all of the case law in the Supreme Court has repeatedly said that the police and the prosecutors are under an obligation, and the prosecutors are under an obligation to determine and get information to the defense attorney. This isn't a situation where, I have to track it down and say, oh, by the way, I didn't see any tips that you gave. Are they there? No. They suddenly discover, Judge, that whether, and I want to be careful, whether the police have been sitting on these or whether the prosecuting attorney just discovered these, it doesn't matter. The fact is they're providing me 500 tips, and now I'm getting those, what's in essence just 5 or 6 weeks before this trial is supposed to start. And I'm supposed to spend my time going over 500 tips to determine whether there is any information on there that potentially could be exculpatory. That's just one piece, Judge. I appreciate counsel pointing out that, well, we only gave Mr. Pryor summaries when we gave him the information. I would beg to differ for his other explanation, Judge. On the GPS, it was a face sheet. On the Faro scan, it was a face sheet. On the 12 terabytes of evidence, it was a reference and a small amount of journal entries. And then what had to happen, Judge, is I had to file a specific request for discovery when I passed that information along to my experts, and they said, where's all the meat and potatoes of the evidence that they didn't provide? Where's all of this information that they did not give us? And then they provided that to me, Judge, and that's only been done in less than the last month. So in the last month, even though they've had a preliminary hearing on the original charge where their expert got up there and talked about waypoints 3 years ago, and then they have a grand jury proceeding, and there's discussion about that as well, and then suddenly now in February, after all of these steps, they provide me 500,000 waypoints that I'm supposed to process. And I didn't hear an explanation as to why they mishandled the evidence. I didn't hear an explanation as to why they weren't able to provide me all the evidence. What they did provide is an explanation saying, well, we just discovered that, oh, by the way, we didn't give you all the evidence in a capital murder case. We've just discovered that oops, sorry, but here it is now, and you're supposed to be ready. I'm sorry we didn't get it to you in time. I'm sorry that, oops, our mistake because our police aren't doing their job, and their incompetence has stopped us from getting evidence until 30 days before trial. I'm sorry that my state lab just discovered additional DNA evidence on the 24th or 25th of December, even though we've had a chance to look at this thing for what has been 2.5 years. I'm sorry that we're supposed to do that. And then they're going to try to kick it back on me and say, oh, Mr. Pryor objected to the consumption. Well, with all due respect, Judge, if this is the manner in which the state lab conducts themselves, and they suddenly start discovering new evidence, and new DNA evidence and new hair samples, please forgive me if I'm not ready to jump all in with the state lab and say, you handle it and just give me your report because I completely trust you. Quite the contrary, Judge, I have some serious concerns about what this state lab is doing. I have serious concerns about the way they're handling things. I have serious concerns that in August of 2022, this state lab was provided information and DNA samples to do something, and they sat on it with no explanation whatsoever until February. And now the court is saying, well, let me get that report, and that's going to hinge on whether or not I consider Mr. Pryor's motion for severance. Judge, even if you get me the report today, before I leave, Dr. Hampinkian needs to go and do his own mitochondrial testing. Dr. Hampinkian needs to identify who those hairs belong to. If you're suggesting in a capital murder case that holds the ultimate penalty as punishment, that I'm supposed to just ignore the fact that this state lab, according to their own pleadings, oops, we lost something. We misplaced something. We didn't do our job correctly. And I'm supposed to rely on their expertise and say, well, we weren't able to identify whose hairs they were. But don't worry about it, Mr. Pryor. You don't need to know anyway, because it's not really important whose hairs were found on this particular piece of evidence. It's not important to you in this case. Just disregard it, and that's basically what they're saying. Oops, don't worry about it. I don't think oops, Judge. I want to know whose hairs those are. I want to have the opportunity to test that independently by my own lab. I agreed last minute to let them do their testing and do that in the interest of trying to process this and get this moving along.
Well, that is an important point, Mr. Pryor, is that you did stipulate to that testing.
Yeah, and I stipulated, Judge, because if I didn't stipulate, then I would have been accused of sandbagging and delaying this thing for purposes of getting a severance. What I stipulated to, Judge, is on the 25th or 24th when they notified me, or 26th, I could pull the email up, they notified me that, hey, guess what? We found some more evidence. You're right, Mr. Wood and I diligently said, listen, let's try to get some testing done. But if you look at that stipulation and read it, Judge, it says that does not preclude me from doing my own independent testing. And the fact is, Judge, they weren't going to hand it over to me. Part of the problem is this, is that what I would like them to do is say, hey, we found some evidence. Give it to me. I'll test it. I'll take the time to find my own expert, and guess what? I'll share my results with you. I'll let you guys look at my results, and you guys can decide whether you want to do it. I should have every right to do that like they did, but that's not the way it was going to work. They weren't going to release it to me, and the only thing I could agree to, because I objected to consumption, is, all right, let's have a mutually agreed upon lab, test this stuff as quickly as we can, but please understand and look at the stipulation. I want to do my own independent testing of that evidence, and I insist on it. I want my expert to do it, and I'm not going to be hurried. I'm not going to be rushed, and if this court decides to go forward, go forward. And I will make representations that I have not had sufficient time to test DNA evidence. I was provided tips at the last minute of information that have been sitting in the police officer's possession, and by association, this prosecutor's possession. The Faro scanner that they provided me was a piece of paper that said, hey, there's a Faro scan. And then I had to do a compel to get the rest of the information. The same thing, the summary they talk about with the GPS were a couple of pages, and then I had to turn around and say, give me the 500,000 waypoints, and that just happened in the last month. The chain of custody was just provided to me 2 days ago. The 12 terabytes has not been provided to me. And if the court wants to insist that, oh, maybe I should have gone down to the prosecutor's office and spent a week and a half waiting for them to download, they do not get to sit there and make my job more difficult because they obtained evidence and confiscated evidence and then said, hey, guess what? There's a lot here. You guys have to go and provide it at your own expense and go down to do that. That's not what the intent was of being able to examine. Judge, I could spend 3 months in front of their office examining these devices. You do not get to make my life more difficult to do that. They have to provide it.
Devices, Mr. Pryor, that is the standard way things work. When the state has evidence, it keeps the evidence in its custody, and defense is allowed to review the evidence. And if you were provided an opportunity to review those electronic devices and didn't go do that before now, as long as you were given access to the devices, then that's how evidence works. Evidence doesn't just start floating around to defense attorneys out of the state's custody. And I see the state's point on that if it was made accessible to you. Now, if you're telling me they wouldn't provide you access or didn't tell you they had it, that's a different story. But I think on those electronic devices, that puts the burden on you to go see what they've got and review the evidence there, and they're not going to release it to you.
Okay. And Judge, I beg to differ with you. I respectfully differ with you, and I think the Supreme Court would differ with your assessment that the sheer magnitude of the evidence, and I provided cites that would suggest, Judge, that they don't get to just sit on their laurels and say, oh, by the way, we have this incredible amount of evidence, and even though we gave you a little bit of pieces of it, by the way, just because, Mr. Pryor, you didn't go down and download it, that's your fault, and oops, I'm sorry. I don't think the Supreme Court would agree with your assessment, with all due respect to the court. But the fact is, Judge, is simply this, is that I put an affidavit and a declaration by Dr. Hampinkian that has not been contested in any way that suggests that in 8 weeks, he can get me a report as it relates to whatever this result is of their mitochondrial testing. And that's going to require him to do additional testing and additional evidence, and it's going to take some time. And it's not going to happen before this trial starts. And what I'm asking is, Judge, given the fact that I find these disclosures, and by their own assessment, oops, we forgot to provide you the tips. Oops, we didn't give you the GPS. Oops, we didn't give you the chain of custody. Oops, we didn't give you the DNA and we just found out about it. Oops, we didn't give you the Faro scanner. And oops, they didn't give me the 12 terabytes. And with all respect to the court, I understand what the rule says. I also understand what the Supreme Court says as that refers to them making it accessible to me and not providing a burden to me to have to do that. And I would suggest, Judge, that by confiscating 32 phones, confiscating 26 journals, they don't get to say, oh, by the way, come down here and make copies of it and look at this stuff. They don't get to impose that kind of a burden on me. They've got to be able to provide that to me, and they've got to be able to provide it as part of their discovery, considering the fact that they gave me pieces of it and they were able to download it and do that. Now, Judge,
you've said over and over the Supreme Court said, where does the Supreme Court say
Judge,
that?
I think, I apologize, I don't have my laptop in front of me, but I believe I referenced that in my initial Brady violation. I believe the case site is in there, and it's referenced to where the Supreme Court has made reference to the fact that they don't get to provide a burden to me to do that. And I would encourage the court to review my motion in regards to that, and I believe the site is in there, 3 or 4 pages into the site, I believe.
Okay.
In conclusion, Judge, what I'm asking, in addition to, if the court's not willing to dismiss the indictment, I am asking the court to consider sever. I'm not going to go any further on the severance on this topic. I'll just touch on it briefly as part of that. But what I'm asking as an additional remedy, Judge, is I provided the prosecuting attorney's staff with a 16 terabyte hard drive today. What I would like is the prosecuting attorney to download the entire case file onto that 16 terabyte hard drive so that I can make a determination as to whether or not there's additional oopses that they haven't provided me, or additional evidence that maybe, oops, by the way, we just discovered, like this most recent disclosure, that we forgot to give you some additional evidence. Thank you.
All right. I'll conclude the arguments on the motion to dismiss the indictment. Counsel, I am going to take that under advisement, but I would like, as I mentioned previously, a follow-up communication, if I could, from the state to include counsel upon your receipt of the private lab testing results. The court would like to be advised of whether or not the private labs determine whether there's a testable amount of DNA in that evidence, and I'll take that into consideration in addition to what's been argued today and briefed. So that'll conclude the hearing on the motion to dismiss the indictment. Mr. Pryor, you've also got a separate standing motion to sever. That was filed on February 13th. The state filed a response to the motion to sever on January 13th, and then a supplemental response also filed by the state on February 21st to the motion to sever. You've touched on some of those issues already in your first argument as it relates to severance, but if you'd like to now argue the motion to sever, you may.
And Judge, for the record, I believe my motion to compel deals with the DNA evidence, and I think the court directed that appropriately. If the court wants to, we can skip over that motion to compel, because I feel like if the court's going to be notified, I assume then that I'll be notified what the results are, and that should resolve that issue. So we can move on from there in terms of the motion to compel.
Very well. Ms. Blake, did you want to address directly the motion to compel that was filed, or consider that under advisement based on argument made already?
And Your Honor, I think Mr. Wood was going to address the motion to compel. However, I think in the list of order, the motion to sever was next. Are we going to skip over that and head to the motion to compel?
Well, Mr. Pryor indicates he thinks it's basically before the court, so let's go out of order and just bring up that motion to compel to see if there's any remaining issues to be argued. Then we'll come back around to the motion to sever. Go ahead, Mr. Wood.
Thank you, Your Honor. I'll be very brief. I think there's some dates that need to be pointed out, and they are pointed out in the state's response on this motion to compel. I think it's important to lay this record because I think Mr. Pryor has certainly cast his fair share of aspersions on the state and law enforcement today. I want to point out on the record that these devices that were seized from Mr. Daybell's house, the indictment in this case was May 25, 2021. Mr. Pryor had the report on those devices January 14th, 2021. So more than 4 months before this case was even filed. Included in that document provided by the FBI that the state provided is a list of the journals. So when he said earlier we didn't provide that, that's false. We did. I think that's important to put on the record. Further, once the indictment was filed, that same document by the FBI was provided again on August 9th of 2021. And then when the state received this hard drive of raw data, we disclosed that on May 31st, 2022, shortly after we got it. The court has already stated its position, which the state agrees with. I just think for purposes of the record, it's important to have those dates. So that's all I have, Your Honor.
All right, thank you, Mr. Wood. So we're a little out of order here now, Mr. Pryor, but that was in response to your motion to compel, which you indicated you thought was submitted. If you'd like to offer any rebuttal argument on what was just said on the motion to compel, then we'll conclude on the motion to compel.
And just briefly, Judge, Mr. Wood was correct that about the notation about disclosing it in the other case, just not in this case. And the fact is there was a disclosure of one journal information. I'm just wondering about the other 25 that are out there that they can, I guess, claim that it's not relevant information. Quite frankly, that's not up to them to determine what's relevant. I get to make my own assessment, and I'll stand by my previous argument, Judge. Thank you.
Okay, that will conclude any argument then on the filed motion to compel that was filed February 7th. I've also considered the state's response that was filed on that, and it's under advisement as well. So we'll end then with the second renewed motion to sever, and any further argument on that, Mr. Pryor.
Judge, I think I touched it on most of the issues in my previous argument on the motion to dismiss, and I'm going to ask the court to incorporate that argument into this argument as well. I want to point out that yesterday the court made a ruling on the 404B as it relates to certain other acts. And I'm going to renew what I've said in my previous motions to sever all along, Judge, that the defense does not have an obligation to file a motion in limine to exclude certain information and certain acts. However, the prosecutor in 404B only applies to a prosecuting attorney trying to bring in 404B evidence. It does not apply, and the statute specifically states that it's the prosecutor who has to do that. Now, this prosecutor has elected now on certain 404B evidence to bring it in. And the difficulty is some of that 404B evidence is extremely prejudicial as it relates to Ms. Vallow, in my mind. And the difficulty is that I think that based on the court's ruling, much of that 404 evidence, even with a limiting instruction, is incredibly prejudicial to Mr. Daybell's right to receive a fair trial. Now, a combination of what I consider discovery violations and this late disclosure of discovery, and at this current time, we're waiting on a report on DNA, whether we're going to get it or not, I don't know, with 21 days to spare, and the court's saying, well, we weren't able to find whether or not there's DNA. Well, the standard isn't that, Judge, because quite frankly, if they can't find any, I get to make an effort to try to find some. And I'm going to make that effort if I have to. If they aren't, I want them to turn everything over so I can make my own independent assessment to determine whether or not their lab that I agreed to send it to did the job correctly. And part of the stipulation is that it's videotaped, and the evidence needs to be provided to my expert to see if there were any irregularities. And at this point, a combination of the 404B and my ability of my client to get a fair trial when you're bringing in, and I know they're two separate trials that are joined, but the fact is the prejudicial information that's brought in against Ms. Vallow is going to have an impact on Mr. Daybell's right to a fair trial. This last minute providing of discovery is prejudicial to Mr. Daybell getting a fair trial. And I'm making this representation, I've made it before. I'm not going to be ready for trial. I can't possibly get through all this information. And Judge, even with the 16 or the 12 terabytes, even if we take that out, Judge, the rest of the information will not be completely reviewed until after we start trial. I just can't get through it, and I just can't get my experts to review all of that, even without the 12 terabytes. Providing the 12 terabytes just adds more complication to it. And if the court wants to blame me and say, oh, Mr. Pryor, you could have gotten it, so be it. I beg to differ with you, but so be it. But the rest of it, Judge, can't get through it. I can't possibly get through that. And Mr. Daybell has the right to effective assistance of counsel. He's chosen me to do this, and he's repeatedly expressed his pleasure in the job that I'm doing, and I think he would say that today. But the reality, Judge, is that given all of this late disclosure and the fact that there's still not disclosure of evidence in terms of DNA evidence has prejudiced his ability to get a fair trial. And the only remedy that I can see, other than dismissing the indictment and requiring them to download a complete copy of the entire case file to me, is to sever these cases and give me additional time to do what I need to do to provide Mr. Daybell effective defense in this case.
All right, thank you, Mr. Pryor. Who's responding on behalf of the state?
I will be on this one, Your Honor.
All right, Ms. Blake, if you'd like to offer argument in response on this motion you made.
Thank you, Your Honor. And I think, as Mr. Pryor has indicated, the arguments have become somewhat conflated between the three various motions that we had pending before the court today. In reviewing the initial filings by the defendant or by the defense, we could tell that there was going to be some crossover. However, when we look at specifically the second renewed motion for severance, again, we're talking about the discovery issues. That's what it boils down to, is Mr. Pryor now saying there's too much discovery for me to get through before trial. This court is well aware, and all parties have repeatedly represented, that there is a voluminous amount of discovery in this case. In an abundance of caution, as Ms. Rawlings said, the state has been going back through, reviewing everything to ensure that we did not miss turning anything over. The state is well aware of our obligation under Idaho Criminal Rule 16, as well as the Brady line of cases, and the obligation on the state to absolutely turn over any exculpatory or material evidence to the defendant. What I think is being missed here, though, and I think there's some loose allegations being thrown around today regarding the state's incompetence or misconduct. And there have been those allegations and assertions repeatedly made by Mr. Pryor. However, the state in this case has tried to be completely forthcoming. We're trying to do things in an abundance of caution. We're trying to do things to show good faith, such as the DNA testing. As stated, once it was determined, at the last hearing I covered that, and I had indicated truthfully to the court, we couldn't know if that was exculpatory or not because we were waiting on the lab results. Days later, we turned over the lab results. We were able to get them to get those to us, and the lab results were that they were unable to locate DNA. We found a new lab. The state didn't have an obligation to have this evidence tested. The defense at any point could have called the state lab in the last 2 years. They could have called, they could have asked to go review the evidence. They could have done something, they could have pushed the state lab, they could have made calls to them. There was no restriction on the defense contacting the state lab. There was no restriction on the defense going in to observe those materials. The defense chose not to. For whatever strategic purpose, trial strategy, whether that's to get us where we are today or otherwise, that was a strategic decision made by defense counsel to not follow up on that. The state got the testing done when it was determined that our state lab could produce no results, but they told us there could be other potential testing which could potentially produce DNA results. As Ms. Rawlings stated, we went out of our way to find a lab that could do that. We immediately notified Mr. Pryor. We had notified Mr. Archibald and Mr. Thomas of that. Mr. Pryor agreed to have those hairs sent off to that lab. We expect those results today, as we've said, and I know the court has indicated you want to see those as soon as we get them. We're hoping to have them today. But again, because of the nature of the evidence discovered, as we represented last time, our state lab was not hopeful or confident that they would get DNA. Again, with this same lab, they're hopeful, but they don't know that they can even extract DNA, given the specific type of sample that we located. It wasn't that the sample was just discovered, and I think we've gone over this before, but because it continues to be an issue, I think we want to make clear for the record, the DNA at the state lab, they go through their process, and there's a couple different things that they're looking for, and that can include latent prints, and that can include DNA. When they're going through the process, they're determining what type of evidence they're most likely to obtain, because certain testing can destroy other parts of the evidence or the ability to test a different way. So when the state lab got to a point that they found that, they stopped. They did exactly what they were supposed to do. They didn't just make a decision on their own to continue testing. They stopped, they notified the state, defense was notified. Hey, we have a piece of evidence that if we move forward, it is going to be consumptive. We've already outlined, there were discussions about that, and ultimately defense counsel for both parties agreed to the consumptive testing. That couldn't happen until Ms. Vallow was found competent and we could move that case forward. The parties were well aware of that issue. Once that was found, the state lab then did conduct that consumptive testing, and only at that time were they able to actually see these additional items that were discovered that have currently been sent off for additional testing. It wasn't the state not doing their job or the state lab not doing their job. It was actually them following the proper protocols that were in place. Again, defense could have asked at any time to go look at that evidence. He chose not to. And with regard to the terabytes that have been brought up, and we've also had journals referenced. Again, and I think there was maybe a little bit of confusion by what's being said about the journals. The state disclosed the existence of those journals. As Mr. Pryor repeatedly points out in his motion to sever, or in his second renewed motion for severance, he repeatedly points to case law that would add an additional burden on the state. And he's not wrong that some cases and some courts have found that. They found that if it is a voluminous amount of discovery, rather than just turn it over, the state should go through it to look for Brady, what could be considered Brady evidence, so exculpatory or material evidence. It doesn't say anywhere in any of the cases he's provided that the state has to go through and provide a complete accounting for every little piece of evidence or every statement or every minutia that could be in that discovery. It says exculpatory. And I think defense repeatedly conflates exculpatory evidence with simply what would be additional discovery. And throughout all of his motions, that seems to be conflated. There are repeated allegations and repeated statements and repeated references to definitive exculpatory evidence. And yet there is no reference to actual exculpatory evidence being contained in any of these documents. The defense also, and it's the catch-22, and we see that in one of the cases cited by the state, in United States v. Palulo, which is a Third Circuit case, 399 F3D 197. And that was a case from 2005. In that particular case, there was an immense amount of discovery. The discovery belonged to the defendant. It was recovered from his business. When they talked about what the government's obligation was in there, they talked about the fact that the defendant was the only one that could comprehend it all in its entirety, that he alone, an obviously highly intelligent person, was able to keep track of it all and manipulate it to his advantage. The court basically said there was so much discovery in that case that to say the state should somehow have that extra knowledge or have the ability to go through it all and pull out anything that might be exculpatory or material was basically ludicrous. It was actually the defendant that was in the better position to look at that. In addition, the defendant himself argued, I'm the one that should determine what's relevant or what I'm going to need to defend myself. We have repeatedly heard Mr. Pryor say that. The state doesn't get to tell me what I get to use. The state doesn't get to tell me the value of this. The state doesn't get to tell me what's exculpatory. So it's the catch-22. On one hand, he's arguing the state has this absolute obligation to go find anything exculpatory in any voluminous amount of discovery and point me to exactly where that is. But on the other hand, he's saying, I don't trust the state to do my job for me. I want to do that. So respecting that and looking at the state's obligation, the state has reviewed those materials. And again, to be clear, case law doesn't say the specific prosecutor or even a prosecutor has to review that, but someone within the state's team. The state has done that. Anything that the state has found that has been determined to be exculpatory has absolutely been pulled and turned over. This isn't something where none of the 12 terabytes from these devices was turned over. This is a situation where they were looked at, what was determined material to the state's case, or if there was anything exculpatory, it was pulled, and the defense were given specific reports or the data for those specific devices and that specific information. That has been pulled over, that has been provided. Any allegation or assertion that the state now intends to present 404B evidence off of those 12 terabytes that have not been provided to the defense is simply inaccurate. Anything that the state intends to use off of those 12 terabytes has absolutely already been turned over. It's been pulled out. As defense argues the state has an obligation to do in his case law, we've done that. We pulled it out and we provided it. If the defendant's position is, I'm the only one in a position to make that determination, he absolutely had the ability to come and look at that, as we've repeatedly said for years now. He's known about the existence of the journals. He's known about the existence of these devices and their contents, that we were able to pull stuff off of them. For whatever strategic reason, defense chose not to ever ask to set up a time to come look at those or pursue that any further. The state does not have to, and Rule 16 makes clear, and case law makes clear, the state does not have to turn over a complete copy of the file. They have to notify defense of the existence and make it available.
In this 12 terabytes of electronic information, is there information the state's retrieved out of that it intends to introduce as evidence in its case in chief?
Yes, Your Honor. I wanted to double check with Mr. Wood since he'd been looking through the motion to compel more clearly and specifically where the things are Bates numbered, but we absolutely have disclosed certain devices. As an example, things from Tammy Daybell's phone have specifically been pulled and provided to defense because the state intends to introduce those in our case in chief. And any other similar evidence that the state determined had relevance, or again, if we determined something was exculpatory, that has been pulled from the 12 terabytes and it has been handed over.
Okay, that was my follow-up question. So what the state would intend to introduce out of that has specifically been identified and provided?
Correct.
Okay, thank you, Ms.
That's correct. And just looking at the case law, and again, I know the court's already gone over this, but looking specifically at United States v. Bagley, 473 U.S. 667, specifically says the prosecutor is not required to deliver his entire file to defense counsel. Certain documents or tangible objects may be of a nature that require counsel to view or inspect them, and that would comply with the Idaho Criminal Rule 16. And in addition, Dunlap v. State 141 Idaho 50, we see the Idaho Supreme Court finding the state does not have a general constitutional duty to provide a complete and detailed accounting of all police investigatory work to defense on a case. Now, we have provided the accounting. We have gone through, we provided the reports, and again, in an abundance of caution and to ensure that we've complied with all discovery, we've turned over things that are not specifically required under Rule 16. We've tried to do our best and use due diligence and caution to make sure that defense has access to everything. And again, going back through, we recognize the state has discovered things that ended up not being disclosed. We promptly turned those over and disclosed them, such as the tips. The tips similarly include a chart at the beginning. I'm trying to think of the best way to phrase that. Maybe a table is probably better, with a review of those tips. Of those tips, law enforcement followed up on specific tips. Defense was provided information regarding those. Again, law enforcement or the state, using discretion to determine what had evidentiary value or could be exculpatory, those were turned over and they were followed up on. I understand the defense's frustration with getting those late, I do. But those tips relate to a time when kids were missing. They relate to a time before the bodies of the children were located. So anything that did have evidentiary value from those tips was absolutely followed up on, and there are reports regarding that have been provided, and there is the table at the beginning of those tips also. So for defense to represent that initially there's 1,188 tips and then correct it to there's 500 tips, it appears that there's repeated attempts to exaggerate the amount of discovery or the lack of notice of the discovery that has been made throughout these proceedings. And at times that is corrected. But to say that defense was not aware of this evidence is simply inaccurate with regard to the terabytes, with regard to the DNA. They were aware, chose not to go to the lab, chose not to follow up on that. They were aware of the 12 terabytes, chose not to set up a time to review that, not to do any follow-up on that. They were aware of the existence of the journals. And again, I think there was a little confusion there. The journals were disclosed that they were in the state's possession. Again, the state went through, just like everything else, went through those journals, determined what they believed had evidentiary value and or anything exculpatory, and those were pulled, and that's what Mr. Pryor references to getting, are specific journals or journal entries. But the existence of those journals was known. Those journals and the devices that are being referenced, I think it's important to note, were taken from the defendant's home. So similar to the Palulo case, the defendant may be the one in the best position to know what is on those, to be able to sift through them quicker than the state could even do that. But again, the state has specifically highlighted things and turned them over where we made a determination that there is evidentiary value. And again, I know defense's response is going to say the state doesn't get to tell me what has value. The state doesn't get to tell me that. That's a fair assessment. We have that obligation to go through the discovery under certain case law. Certain case law says the state doesn't have that obligation. But even if we assume that this court goes with the line of cases saying that in a voluminous case we should have that obligation, the state has done that. But the counter argument immediately from defense will be, I get to make that decision, which is exactly why the device and that evidence was made available, so that he could make that decision. Again, strategic decision on defense not to do that. But to come in and argue that it's the state's fault or to put additional burdens or requirements on the state is simply an inaccurate interpretation of any case law that I've ever seen. Similarly, when we look at, and it's a case out of Ohio, but it's State v. Widmer, and that citation that I have is going to be Lexus, let's see, actually I have the Westlaw citation, 2013 Westlaw 142041, and it's an appellate court case from the state of Ohio, but just dealt with a similar issue. And it finds that as a rule, undisclosed evidence is not material simply because it may have helped the defendant to prepare for trial. In that case, the vast majority of the defendant's argument and brief was how the perjury was material to his strategy at trial, preparation rather than guilt or innocence. And I think we've repeatedly heard those type of arguments as well, that this is unfair because it affects my trial prep. It's unfair because it affects my trial strategy. And at least one court in Ohio has said that actually isn't the test for Brady. The test for Brady is whether it would affect guilt or innocence finding, not whether it would affect someone's attempt to prepare their trial or to change strategy partway through trial. In addition, in United States v. Salyer, and that was a case cited to by the defendant with regard to having to turn over, or for the state having the requirement to go through voluminous discovery and point out exculpatory information. The court in that case, though, went on to provide, the Supreme Court has directed prosecutors to err on the side of disclosure, but it has not held that exculpatory or impeaching evidence is to be speculatively gauged by what defense counsel may desire to argue. And again, I think those are the type of arguments that we're hearing. We're not hearing that these are actually, that there's any actual exculpatory evidence or information. What we're hearing is this affects how defense wants to present their case or their strategy. And I would note in the Palula case as well, the court found that as a practical matter, no one, either prosecutor or defense counsel, can ever expect to get all of this material under control. There will always be something more which can arguably be relevant to the issues in this case. And again, in Palula, that was, and I don't know if I gave the court the citation, 399 F3D 197, and it was the Third Circuit case. Different type of case, dealt with some kind of a financial crime, but I think, as this court has repeatedly heard, there is such an immense amount of discovery in this case, and to say that there couldn't ever be anything in the future, somebody coming forward, something like that, there may be ongoing discovery well into the future of someone coming with more information, or somebody arguing that something could have been material or relevant that wasn't highlighted or pulled out. And in that case, similarly, the sheer volume of documents interspersed through many jurisdictions, many of which could be relevant to any or all of the various prosecutions, seriously weakens any claim that the government suppressed evidence. And then that's when they also had talked about the defendant saying it's up to him to decide what's relevant. Similarly, in this case, we have a case where there are actions that have spanned jurisdictions. We've had multiple law enforcement agencies involved. And again, there's just been an extreme amount of discovery produced in this case. And I think further, the defendant continues to harp on Brady, but we're putting the cart before the horse. There really can't be a Brady violation at this juncture. And then even furthermore, again, there has been no actual showing or pointing out of any exculpatory information or material evidence that the state has not disclosed. There's simply been conjecture that within this 12 terabytes, within these journals, potentially with the DNA that has not been able to be tested, that there could be exculpatory evidence. And for the defense to say, I absolutely want my own expert to test those, the newly discovered DNA or the newly tested DNA evidence, if it comes back as something by the states, with the lab that the state located that's been, there's been a stipulation to have that lab test, I'm not sure that you could say definitively additional testing would need to be done. Of course, I recognize that would be up to the defendant and his trial strategy, but if it comes back as exculpatory for Mr. Daybell, I'm not sure that additional testing would be necessary or required. But again, I know defense will say that's the state asserting themselves into the defendant's position. I'm not attempting to do that, but just pointing out to definitively say it's necessary, I think that may be a little premature to make that assessment. And the defendant also cited the United States v. Skilling 554 F3D 529. That's a Fifth Circuit case. And the court found as a general rule, the government is under no duty to direct a defendant to exculpatory evidence within a larger mass of disclosed evidence. And in that case, they talked about the fact that it was turned over, it was a mass amount of discovery, but it was turned over in a format that was searchable. A lot of the discovery from the state has been turned over in a PDF format or some other searchable format where the defendant could search that. And again, the discovery that has not been turned over has been accessible to be viewed. And at this juncture, any time that the defense has asked to review discovery, because that has happened a couple times, the state has absolutely made those necessary accommodations. This isn't a situation where the state would not have made the accommodations, or if it was going to take defense a week or 10 days to look at that, the state absolutely would have accommodated that. And I think our actions in this case have shown that when defense has asked to review discovery, we've absolutely made that available. And we've made law enforcement available as well for them when requested to assist with reviewing discovery. Part of the argument here, while it's couched as a second renewed motion to sever, and the state would say the defendant has still failed to meet the high burden. We've talked about that in the past filings. There is a very high burden for the defendant to meet to get a severance and to show that there's absolutely no other remedy than to sever the case. The standard remains the same no matter what the argument is by defense. The state's position is the defendant has still failed to meet that burden, and what this is in part is an attempt to get a continuance. And the defendant has said that he's previously filed a motion to continue, and as part of that, there's been the recognition that the case would have to be severed in order to get the continuance, or at least most likely would need to be severed based on Ms. Vallow Daybell's assertion of her right to a speedy trial, which she absolutely has the right to do. So looking at that, in State v. Ochoa, 169 Idaho 903, the Idaho Supreme Court has found to qualify for a continuance based on a late discovery, a party must not only show that the late disclosure generally prejudiced the party, but they must also show that a fair trial was denied because there is a reasonable probability that the result of the proceedings would have been different had the additional time been granted. In that case, Ochoa waited until the morning of her trial to request a continuance based on information in a toxicology report that she felt she really didn't get to explore more fully. The court found that merely claiming that additional investigation could have taken place is not sufficient to demonstrate unfair prejudice so as to support a motion for a continuance. The court found that while there was a late disclosure, Ochoa had previously been advised of the results of the toxicology report. The substance of the report had been disclosed months earlier, and the late disclosure did not change the contents of that report. And in order to get a continuance based on a late disclosure, the defendant must show that there was prejudice such that the defendant's case preparation, so much prejudice to the defendant's case preparation that a fair trial was denied. And in addition to that, the defendant would need to show that there is a reasonable probability that but for the late disclosure, the result of the proceedings would have been different. So again, not just the trial strategy itself or the defense preparation, but that the actual result of the trial would be different. And again, in this case, the defendant knew of the bulk of the evidence or had the ability to go and access it that he's now arguing he was not provided by the state. And similarly, when we look at State v. Coswell, 121 Idaho 801, the Idaho Supreme Court had determined that even if the state's original response was inadequate with regard to discovery, there was no abuse of discretion in the court's conclusion that Coswell's failure to for 5 months to pursue the matter further and request more specific test information, such as a computer printout, or to obtain his own expert and request that portion of the remaining contraband to be submitted to his own expert, precludes him from complaining about any perceived inadequacy of the state's response. And again, the state would argue we're in a similar position here. The defendant has, as he repeatedly says, that the state's waited till the eve of trial to do these things. The defendant has actually waited until the eve of trial to bring these issues before the court. We didn't see motions to compel from the defendant until recently. The state has received no request to review the specific discovery until recently. With the exception of the tips, and again, the information was pulled and provided that the state had determined was relevant. But with regard to the DNA testing, the defendant had the ability to go in, look at that, request testing, request to move something forward, file motions with the court in regards to that to try to move the process faster. The defendant did not do that. The defendant did not request to come and look at the 12 terabytes of information that he now wants to claim the state should have disclosed, that he's known about for 2 years. The defendant did not choose to come and look at those journals, and now on the eve of trial wants to complain that he was not given adequate notice or was not provided that discovery. In looking at the rationale applied in Coswell, that's not good grounds for a continuance if the defendant simply didn't follow through with those. Again, the state does not pretend to guess at the defendant's trial strategy. We don't know the reasons those things were not done. But again, I think it's disingenuous to come in and now blame the state and say the state didn't follow through with our obligations when we have met our discovery obligations and we've gone over and above at times to try to ensure. As Ms. Rawlings indicated, the late location of that additional DNA, the state's gone over and above in finding a lab. We had no obligation to get those things tested further than the state lab saying we can't test them. But out of courtesy and good faith and a showing of good faith, we located a lab to test those quickly. So for all those reasons, the state requests that the court deny what is really a motion to continue and also deny the motion to sever, since the only reason for the severance would be if the court granted a motion to continue with regard to case number 1623, but denied continuing case 1624.
All right, thank you, Ms. Blake. Mr. Pryor, would you like to offer any final rebuttal argument on that?
I would, Judge. Judge, I find it almost comical that the state in the last 15 minutes turned it all on the defense and said, it's all the defense's fault. It's the defense's fault that I'm not getting the discovery. That's absolutely comical. I'd like the court to go back to August and look at the stipulation that we entered into. And that stipulation was based on the discussion that originally I was saying, listen, you're going to use up all the ability for me to do independent DNA testing on evidence, but we agreed and entered into a stipulation. And part of that stipulation in August of 2022, Judge, was the prosecuting attorney was going to send this to the state lab for testing, and they were going to test it. And as part of that stipulation, Judge, you'll read where it says, this does not preclude each of the other parties from going forward in the future and having their own testing done. And that's similar with the stipulation that was just done in January. To suggest that then what I'm supposed to do when we agree to a stipulation in an order is to start harping on the state lab and say, hey, we gave this to you in August. When are we going to get the results? They delivered the samples. They control the state lab. The state lab is their expert. And I'm supposed to take on the responsibility to say, hey, we gave this to you in August. And by the way, you haven't done anything. You misplaced or lost or decided not to test this information and evidence. And I'm supposed to be responsible? That's comical. And then suddenly, Judge, we have a hearing on a motion to continue. And the motion to continue, Judge, is not some sort of trial strategy. It's to compel them to get me the information that we agreed that they were going to have tested, and I was granted the right to have additional testing in the future. So to suggest that I'm sitting on this thing is comical. And I can't even believe they'd make that argument, given the fact that their expert was the one who decided to test it in August, and I'm sitting there waiting for them to get the results. And I file a motion to continue because I don't have the evidence. And the court makes a reference saying, listen, you put me in a difficult spot. Ms. Vallow wants to have her trial. Mr. Daybell doesn't have the DNA evidence, and he wants the DNA evidence. And I said, Judge, I filed a motion to sever. Okay, we'll hear that. I'm supposed to just say, well, I'll wait for the state to come around and get me the evidence. And lo and behold, Judge, within a couple of days after you make that comment, shockingly, surprisingly, it's an amazement. You got me a report. Wow. It took a judge telling you to get me a report and a phone call from them to their own expert and say, get me the report. And then we find out, listen, there's usable samples to do additional testing. All right, we have to come to an agreement because the communication from the state is that if we do the additional testing, it's going to consume everything. And at first we had to go into a discussion and say, yes, I want additional testing. Yes, they wanted additional testing. To suggest that, well, we don't have to do that. They wanted additional testing on the stuff that the state lab has had since August of 2022. They wanted additional testing. And I agreed saying, listen, we'll agree to an independent place to test it, but these are certain parameters that we have to engage in. But understand, folks, that when you get me the results, I'm reserving the right to have my DNA expert review, examine, and make a report on what that additional testing provides. And I stand by that, Judge. I have absolutely no faith in the state lab. Zero. I have zero faith in their ability to get anything right. And I have every right to do my own testing. Now, Ms. Blake talked about the tips, Judge, and I don't think I misspoke, and I'll stand corrected if I did. I think I said 1,188 pages. And I said on those 1,188 pages, there were 500 tips. And there are 500 tips. And like what the state has done all the time is they give you a snapshot of something and say, oh, by the way, this is what you got. This should be good enough. Don't do any further research into these tips or don't read into these tips. You don't need to because we've decided that this is what's important and this is what's relevant. And here we go. This is what you're waiting for. It isn't the state's job to rule what has evidentiary value, what's relevant, and what's exculpatory. How do I know what is exculpatory, Judge, if I don't have the evidence, if it's not provided to me? So they provided to me, and I'll cite exactly what they said. In the abundance of caution, we got you the rest of the evidence. In the abundance of caution, and we're making a good faith effort. Well, you know what, Judge, in the abundance of caution, maybe I can make a determination what I think they should have from me. And I'll make my own determination. But I'm not sure that's what's going to fly with the court. Again, it's not up to their determination. They're under an obligation to provide me the evidence. And if the court wants to say, Mr. Pryor, you could have gone down there, Judge, it would have probably taken a week just to download the information. It would have probably taken months for me to review the information. And to impose that burden on me to do that isn't acceptable. You can't impose on me and say, we got all of this evidence. And by the way, the lawyers and maybe the staff are looking at it. The staff are looking at it to determine what's relevance. So is there suggestion that they have people who are not lawyers making a relevance determination of what is going to come in and what isn't going to come in and what applies to this case? Because that's what they said. Now, at this point, Judge, they should have been providing me a copy of all of the evidence. And in those journals, those 26 journals include journals of some of his children. And I would challenge any one of us to say, we know exactly what's in every single page of our children's journals. I would suggest, Judge, I don't know what's in any of my children's journals. Maybe I'd be surprised. Maybe I'd be shocked at what some of my children are saying about me. Well, Mr. Daybell has no idea what's in the 26 journals. And this state is still under an obligation, not on their own, to make an assessment of what's relevant and what's exculpatory. They have to provide me the information to allow me to do it. And they should have had to do that, Judge, and to impose the burden on me to have to go over to their office and wait a week and say, yeah, you can download it, provide it to me. By the way, this is the stuff we're going to use, and we made a determination. And since we've already disclosed this to you, don't worry about the rest of it, because there's nothing you really need to worry about. Well, quite frankly, I don't think I need to trust their word about this, and I'm not gonna. I continue to point out to the court that this disclosure in good faith included them giving me screenshots of stuff, and only after I file a motion to compel to get that stuff do I get provided stuff that they've had for a significant amount of time. This is not a motion to delay this stuff. Believe me, nobody wants this over more than Mr. Daybell. Nobody wants this over more than me. I want to get to the trial in this case. But the fact is, Judge, I should be afforded all of the discovery and all of the information. And I pointed out to the court that I understand, I've been doing this for creeping up on 26, 27 years. And I understand when last minute things show up and last minute information shows up. I understand how that happens, and that's why we have relatively liberal discovery rules saying, well, this came across and we need to provide this. But the 6 supplemental discovery pieces that were provided are substantial. The stuff in the motion to compel is substantial. I have not gone through it all, and I'm not going to get through it all. If this court holds me to the trial date, I'm not going to get through it all, and I'm not going to have a chance to review everything. And that's aside from the 12 terabytes. And the fact of the matter is that aside from disclosures and Brady, Mr. Daybell has a right to have whatever time is necessary to provide an adequate defense. And that includes the necessary time to go through all of the discovery. This isn't some tactic that they're trying to put on me, Judge. This is a blatant disregard for doing their job. The idea that they can say, well, in the abundance of caution, we're going to give you additional discovery that we should have given you in the beginning that we missed, that we weren't doing our job and we discovered that you don't have all of this information. But you know what? We'll give it to you at this late game 2 days ago and say, oh, by the way, you're going to need to be ready. Well, the problem that the state points out is, Judge, have I said to you anything that's exculpatory? I think the DNA is exculpatory. I want to know what's going on, and I'd like an explanation as to why they didn't find the 5 hairs until just recently in late December. And I want that information, and I want to test that information. I insist on being able to do that.
Mr. Pryor, if it did come back exculpatory, does it need any additional testing?
Yes.
Why?
Because I want to know whose hairs they are.
Well, what if that's what's determined?
I think, Judge, what they're going to come back with, and I don't know, Judge, is that they're going to come back with a profile like they did on some of the other stuff. And the reality is this, is that they have hair samples from a number of people. They've taken hair samples from Mr. Daybell, they've taken hair samples from Ms. Vallow, and I'm not going to mention the number of other people that they've taken hair samples from. I want to know whose hairs they are. Because if there are hairs that are found on a piece of evidence, and they don't belong to Mr. Daybell, I want to know. I don't want just a profile saying, oh, by the way, it's a male or it's a female. This is what we think. I want confirmation. And on top of that, Judge, if it comes back and it identifies somebody, I want my lab to be able to go through, and I want Dr. Hampinkian, who I'm not bolstering him, but from my perspective, the best of the best. And Dr. Hampinkian gets a right to review all the evidence and make an independent determination. That's what I've said all along. That's what I put in the stipulation in August. That's what I put in the stipulation in January when you folks first decide to discover this new evidence in December. I want my own assessment made. I'm not going to be put in a murder case that carries the death penalty and say, I'm relying on a state lab or some other agency that they decide to pick to make a determination. I have every right to have my expert do an independent review and investigation of all of this stuff to make a determination. And that cannot be done in 21 business days. It is impossible. And to put me in that position is blatantly unfair. And for them to suggest that, oh, well, we've had this since 2020 and they haven't done anything, and it's Mr. Pryor's fault because he hasn't contacted the lab when I vigorously engaged in negotiating stipulations for this and included in each one that I want independent testing done. And to say, well, Mr. Pryor just wasn't doing his job. It's not Mr. Pryor isn't doing his job. It's the state of Idaho that sat on their hands and has decided not to turn over discovery, and whether it's sandbagging or it's laziness, it's them.
All right, well, I will consider the motions under advisement, the motions to dismiss the indictment, motions to sever, motions to compel. They've all been argued somewhat concurrently today. I do not have that update from any further testing results that come in, and that will conclude the matters that are scheduled for hearing today. Council, we did want to address a couple of extra things off the record. Actually, I'll put those on the record, but outside the presence of the public in terms of some trial preparation issues. We'll take a break right now for 10 or 15 minutes, and then I'll have the courtroom cleared, and we will come back on the record with council to discuss a few of these trial administrative process procedures that we're going to be talking about. So we will take a recess and come back on the record shortly.
All right.
Much better than
I tried.
You did.
I had it in the back of my head. I gotta slow down. I gotta, because I could tell I was going fast sometimes. I tried to remember.
Yeah, you did great.
Okay, good. Especially because I'm like, now we're getting towards the end of it. She's probably like,